So granting an agent authority with a power of attorney is obviously a very useful tool, one that we're already working on for you. And this act allows the agent to act on your behalf when you're not able to do so. That's really the primary purpose of it. Common things that we're allowing in this power of attorney are paying bills, signing documents, handling mail, paying taxes. But even though your power of attorney covers many areas, there are certain things that require special procedures and special acknowledgement in order to ensure your agent can do this for you. These are called superpowers. Yes, they are actually called superpowers, which, unlike the traditional powers in your power of attorney, you are, as the person giving the authority, must specifically authorize your agent to do the certain things that are listed here. So let's go over them because obviously you have decisions to make in order whether to allow your agent to do this or not. So this is in the part that's titled special transactions. More or less around the 80s, everyone's power of attorney can be a little bit different. So the numbering may not be the same. I just pulled this out of one of our clients' powers of attorney. So 86 for her, it could be, 88 for you. So the first one is gifts. Do you want to allow your agent to make gifts of your property? Think of it like your agent has your checkbook. If you don't use checkbook, online banking, whatever, an ability to use your money. And you are allowing them, if you say yes, of course, to be able to take your checkbook and write a check to so-and-so for X number of dollars this often. So if you want your agent to make gifts of your property, then we have to go into to whom should gifts be made payable to, how much they should be, and how often. So if you do not, and let's start with the easy part, if you do not want to allow your agent to make any gifts of your property, then you would be initialing this paragraph, which says, my agent may not make any gifts of my property or exercise any powers of appointment I may hold. A power of appointment is the power that you could be given in someone else's will or trust to say who gets your inheritance from that person's will or trust. And you can say, I have a power of appointment in my mother's will, and whatever I was going to receive from her, if I'm dead, I want it to go to my trust or my kids or my will. Most people don't worry too much about that, and that's not really a tool that I recommend, because when we create estate plans, we make them really nice and detailed, so that shouldn't be an issue. But if you are anticipating an inheritance and that person's will or trust gives you a power of appointment, this may be something we need to speak about. So let's say you do want to allow gifts. So here you're going to choose whom to make gifts to. Do you want it to be my children, your ancestors, descendants, other members of my family, my agent, which is important because if your agent is also your child, you may want to consider initialing that as well. If it's for their health, education, support, maintenance, and this is, I include this in there with specificity. You can elect to change some of the wording and make it more suitable to what you want. And that would be in the specify other, or any charities that you want to be able to leave, gifts to. The next part is how much money do you want them to be able to make gifts for? So you can just, put an amount here. The next paragraph is an amount not to exceed the annual dollar limits of federal gift tax. Currently, it's $18,000. We're in 2024 when I'm making this video. So just depending on what year it is and what the IRS says the gift tax exclusion it could be that. If my children agree to consent to a split gift pursuant to IRS code 2513, in an amount per donee not to exceed the aggregate annual gift tax exclusion for the donee for both my son, it should say my child. Sorry, this particular client had a son, for both my child and me. We would have to go over the actual IRS code 2513 to discuss a split gift. But if you are, I would say consider this if you are in a taxable estate. Right now, the taxable exclusion for estate taxes is 13.6 million. And then in any amounts qualifying for federal gift tax exclusion under the IRS code. Very similar to this. This is specific for annual, so it's 18,000 per year, and this is specific for medical and educational. Same thing, in an aggregate amount not to exceed my applicable exclusion amount. 2010C is a state tax exclusion. And then, actually, you know what? I think this says it twice. Yep, sorry, I must have copied and pasted twice. And then for estate planning purposes in unlimited amounts. This is useful when you, let's say you're allowing your agent under the next section to create a trust for your benefit or for someone else's benefit. They will need to be able to make gifts for purposes of estate. They may need to make gifts for purposes of estate planning. So you may want to initial this if you're allowing the next section. With regard to trusts. So if we're creating a trust for you together with this power of attorney, this may not be necessary, but it just depends on who you're choosing as an agent and what we're working on in terms of what assets you have, how we're going to be retitling them, when we're going to be retitling them. If we're not creating a trust for you, then you may want to consider, depending on the trust level you have with your agent, to allow them to create a trust where you are a beneficiary. That could be very useful in the future, depending on your specific, events and facts and assets and family dynamic. If you already have a trust, or if your agent creates a trust, then giving them the ability to amend, revoke, or terminate a trust where you are a beneficiary, or transferring the assets into another trust where you are a beneficiary. Again, this depends on your comfort level with the agent, your specific, assets and family dynamic and wishes. And then here to create, amend, or revoke trusts for the benefit of others. If you choose this, I would recommend defining who others are. For example, if you have a child, you may want, if you have a child and you're getting up there to the exclusion amount, you may want your agent under the power of attorney to create a trust for the benefit of your child. And it could be an irrevocable trust, which means you would lose control over the assets. But that requires a more in-depth conversation specific to your case. And then if for whatever reason the trust needs to be modified by a court, or can be modified without involving a judge, allowing your agent to participate in this modification of the trust. I personally, and obviously I'm giving my opinion, but it really just depends on the facts of your particular situation. I like to include as many provisions in the trust which allow and regulate how to modify the trust. But sometimes it happens where, someone passes away and the beneficiaries need to modify the trust, and they may have to go to court, and this could allow them, or not pass away, incapacitated. And we need to modify the trust because obviously this is while you're alive. And your agent may need to go to court to modify the trust to be able to better serve your benefit. So again, really most of these are going to be fact specific, which is why they're not general powers and they're specific powers or superpowers. Survivorship and other designations. So when you go to the bank, you can name a payable on death beneficiary, or in a retirement account, a survivor. So this initialing here would allow your agent to be able to change who the person receiving these assets are in terms of survivorship. If we're creating a trust, this may not have an impact, because we may just title accounts in the name of the trust. Again, very fact specific, but good, good topic to discuss. Same thing, but instead of an account, it's for a life insurance policy, annuity, retirement account, those kinds of accounts. And then even though this is under the survivorship designation, I kind of couple these four superpowers together. If you are not at a point, but if there's any chance that you could qualify for government benefits, or need to give your agent the flexibility to say no to additional income for whatever reason, initialing these four sections allows them to say no to assets coming your way. Obviously, to waive your right to be, a beneficiary of an annuity or a survivor benefit of a retirement plan. disclaim any interest in property, whether you're going to receive it outright or in trust, disclaim any powers over property as a beneficiary of any trusts, and disclaim any powers of appointment, just like we spoke about, excluding any testamentary power of appointment that I currently exercise. So if you're doing that in your will and you're giving someone, or you're including the exercise of a power of appointment in a will, saying, I'm going to receive this for my mom, I want this to go to my daughter if something should happen to me, you know, this excludes it. But if you have any other powers of appointment that you may acquire, then allowing them to do that may be helpful in terms of qualifying you for Medicaid or any other government benefits. This, in essence, the last four is saying no to additional funds or powers that you may have over funds. I hope this explanation has served to be somewhat helpful. It's really difficult because it's very fact specific, and I tend to explain it to my clients kind of like in the moment because I know their situation, I know their assets, I know their family dynamic, I know what they want. But I wanted to create something that kind of gave a general explanation of these superpowers. You can also refer to a blog post that I did recently with regard to superpowers. And of course, if you have any questions specific to your case, we are more than happy to discuss them with you, and that way we can get you to make an informed decision and make sure you choose the right things for you. Thanks again.